Hello everybody, my name is Lauren Gerhart and this is Legal Research Week 6. So first we're going to be talking about primary and secondary authority. So primary and secondary authority are very different. So primary authority is the law itself. Examples include constitutions, statutes, and case law. So it provides the foundation for the law. And secondary authority is the analysis of the law, such as legal encyclopedias, law reviews, and treatises. So it critiques and helps understand complex areas of the law. It frames arguments, especially when diving into legal topics that you may be unfamiliar with. So primary authority is binding when it comes to jurisdiction that controls regulations or statutes, whereas secondary authority is persuasive as it helps courts understand the implications of certain laws and interpret the language of those laws. Primary supports legal decision making to decide which case falls under which law, and the secondary authority builds the background and provides cases in which similar scenarios have been interpreted by this law. So, second, we're going to be talking about when to use each of them. So, starting legal research with secondary authority can be useful when you are unfamiliar with those areas of law or legal topic. Also, when the primary authority is complex and hard to analyze alone, secondary authority can help with that as well. It can direct you to relevant information and interpretations to further your research before diving into the primary authority. A situation where relying only on the primary authority might be insufficient when the language is broad or unclear. An example of this is the mass debate on the definition of due process in the 5th and 14th Amendments of the U.S. Constitution. Even centuries after the ratification of these amendments, the language and its implications have been debated. So, citing many secondary sources when making this argument is very helpful. So, third, we're going to be talking about interconnection in research practice. So secondary authority enhances the understanding and application of primary authority by explaining the context and clarifying interpretations of that law. Language that it may be very rigid or rigorous, is explained in secondary authority a little clearer. It also helps attorneys persuade courts in issues that are harder to settle. As I had done in some of our papers for this class, I look at case law interpretations to understand some of the KRS statutes that I examine. For a recent paper, I did research on Kentucky child custody agreements, and family law treatises can help immensely with the understanding of what may be very dense statutes or very unclear statutes. You can check the credibility by looking for credible sources, legal scholars, and read the citations that follow. So fourth, we're going to talk about the ethical considerations in legal research. So proper and accurate citations are essential in legal writings. It ensures the credibility of an attorney or an argument, and improper use can lead to the distrust from both the courts and the clients. When cited correctly, arguments are strengthened. Also, and more of an obvious one, it is a professional responsibility for an attorney that your work is grounded in good ethics. It can be considered misrepresentation, and you could potentially lose a case if not done correctly. Over-relying on secondary authority can be harmful to your research as well. So, over-importance of discourse instead of the actual law itself can be seen as not binding, and courts usually decide on binding law rather than the interpretation of it from previous cases. However, it is useful to use secondary authority to build an argument based off of your primary authority. Thank you.